Right. Good morning, everyone. We will make a start. My name is Harry Dyson. I'm in the business and property team at King's Chambers. And today we're going to be talking about Part 36 offers. So here we go without further ado. So the first slide, actually, I can't claim to have done this talk because of this, but it has since become quite topical because of this handsome chap in the middle here, Hugh Grant, who has recently been in the news because he was bringing a phone hacking claim against one of the newspapers and essentially said in no uncertain terms that he had to accept the settlement offer as it was in Part 36 terms, because if he didn't, he would be saddled with both sides' costs. And as Hugh Grant does, he sort of went on to suggest that this is unfair and then robbed him of his day in court and one thing and another. But what it does do is show how important and powerful these offers can be. So with that background as to the importance of them, in case anybody needed convincing, I'm not sure anybody did, I'll run through a sort of a working example of a Part 36 offer and point out some things that I think we all ought to know. Because generally when dealing with Part 36 offers, the need to advise them can crop up in several situations. The first one is at the end of the trial. You might be presented with a Part 36 offer and it's shown to the judge, and you need to know whether or not you can say to the judge, no, that's not a valid Part 36 offer. You don't need to consider making the order indemnity terms and costs and perhaps a 10% uplift and so on and so forth. So it's important you know then that if you can get out of it, you do get out of it. Secondly, you might be mid-litigation and the other side might make an offer, and your client might have seen Hugh Grant in the news and think, this is disastrous, we need to accept. So you need to be able to advise your client on whether or not this offer really is something to worry about, or whether or not it's a dud and won't bite when it comes to the end of trial. Thirdly, and sometimes most importantly, your client says, oh, I've seen Hugh Grant in the news, I want us to make an offer. And what you desperately want to do in those terms is, if you make an offer and you tell your client you've made a Part 36 offer, you don't want to be the one stood at the end of the trial while the judge tells you that it's not valid. Okay, you need to get it right the first time, otherwise it simply doesn't work because of the strict nature of the regime. So with that background, I want to start with a working example of a potential Part 36 offer. Now, unfortunately, my imagination ran dry once I put forward the Love Actually picture, so this is a very boring, basic example. The claimant claims £100,000 from the defendant on the basis that the defendant supplied window frames which were not fit for purpose. So on the face of it, quite a straightforward set of facts. When it doesn't matter if it's in the TCC or otherwise, straightforward case. So in this case, an offer comes forward from the claimant, and in these terms, the defendant pays the claimant £99,950. The claimant says, oh, but I'll only seek 50% of the costs. Alternatively, the claimant would accept the defendant attending the site and remedying the issues and installing a further 100 windows free of charge. And it said the offer is made under CPR Part 36 and is open for acceptance for at least 21 days. Brilliant. The claimant thinks it's made a fantastic offer, and you're sat there with a nervous defendant wondering what to do. So what I hope to do now is break down this offer and point out its issues. And don't all shout out at once, but you might have already spotted a few issues in there. And using this, we'll go through some different authorities. Now, I accept that the example's a little bit garish in how blatant it is, that it might be defective, but what it does do is give us a ground to discuss the different cases. First issue is the offer contains terms as to costs, and that means it's likely not a Part 36 offer. So as a starter, it's important to remember that CPR Part 36, if you are making an offer, or advising on an offer, I would always advise simply getting out Part 36 and reading it start back to front, because it's a very prescriptive regime and you are either inside of it or you're outside of it. The authorities show us, as we'll see, that the courts do not take prisoners insofar as if you find yourself on the fringes or not compliant with Part 36, it simply will not be a Part 36 offer and it will fall to be considered as any other offer under CPR 44. So that's the start. So not a Part 36 offer because it contains terms as to costs. So if we go to the relevant part of the judgment there, is Honour Judge Paul Matthews sitting as a judge of the High Court. And it talks there about the fact that there are slightly conflicting authorities on the point, but essentially the case of Mitchell and James and French and Groupama bind the High Court in this instance, and therefore when they do make provisions as to costs, that means it's not a Part 36 offer. Now, interestingly, one argument that was ran in the case of 1990 is that they said, well, that doesn't make sense because the offer is more beneficial to those accepting it because we're saying we won't have all of our costs. So really, why should we be punished for making a better offer to the other party than what Part 36 would allow? And that was dealt with, that was given short shrift by His Honour Judge Paul Matthews, and it was basically said that may be the case, but again, you have not complied with Part 36, so the consequences do not apply. So the takeaway from this is you can't sort of fudge the Part 36 provisions on the basis that you are helping out the other side. There is no leniency. There is no credit to be given for parties being extra reasonable, if you like. It simply will not be a Part 36 offer. So the first one to pick up on there, if we flick back to the offer, it's B. C will only seek 50% of its costs. If you see such a provision within a Part 36 offer, alarm bells should ring, and you can tell your client, no, night and night, puts us on firm ground. This will not be considered a Part 36 offer. Issue 2, and I've called it going off-piste. Woodgate and Woodgate, another High Court decision, relatively recent one. And this is that the offer advances an alternative basis for settlement, which is outside of the pleaded case. This case involved two brothers. The claimant was seeking the removal of the defendant as the personal representative of his mother's estate. He sought an appointment of an independent administrator and an account of the estate. So fairly routine stuff for those of us who practice in wills and probate and the like. Now, the claimant's Part 36 offer here was for the defendant essentially to buy out the claimant from the estate wholesale for the sum of £351,000 or thereabouts. And because that's what the claimant said was 50% of the estate, which equated to his share. Now, I'm pausing there. A perfectly reasonable offer. That it's one that a judge would welcome should you go in with a tumbling order on the first day of trial. Happy days. It's brilliant. It avoids the trial. No one should be criticised. But does that mean it should fall within the Part 36 provision? No, absolutely not. Let's look at the judgment here. So it starts in the same terms I've set out, subject to perhaps arguments about sensitive terms. It's a perfectly valid offer of settlement, but it's not a Part 36 offer. So when I said at the outset or towards the outset, go back and read Part 36, this is exactly why. A Part 36 offer may be made in respect of the whole or part of, or any issue that arises in a claim, counterclaim, or additional claim. And then there it refers to the issue, the decision in Hartland Sanders, that part of claim and issue are referring to pleaded claims, parts of claims or issue, not any other claims or issue which may have been intimated in some way but never pleaded. So in Woodgate and Woodgate, there likely would be ample correspondence going back and forth, explaining that the claimant was entitled to this, that, and the other. Those issues have been intimated but not pleaded. So going back to our offer, what we see here is the alternative remedy, which, it's unlikely that would ever be pleaded. But say, for example, if we forget the installing a further 100 windows free of charge, perhaps if it was simply attending site and remedying issues, some sort of species of specific performance, possibly. The first thing you should do is go back to the pleadings and actually look at what was pleaded. And if that's not pleaded as relief, then there you are. It simply is not a Part 36 offer. And again, as with the terms that were more beneficial to the offeree than the offeror, you may say, well, this doesn't make any sense. It's a very reasonable offer. It goes in reality to the issue in the case, because let's face it, that's what the two brothers wanted. They both wanted each other out of each other's hair, and they wanted the estate resolving. Fine. So you could stand back and say, well, actually, this goes to all of the issues in the case. This is what we're here for. But not what was pleaded. It's not there in black and white. Therefore, it's not caught by Part 36. So when assessing your own offer or the other side's offer, be strict, be thorough, and really be forensic. Don't forgive the other side for straying slightly outside of what's pleaded. If it's not there, have a run at arguing that it's not a valid Part 36 offer. And based on this authority and similar ones, you should really have good prospects of success. So those are two issues. And in case anyone had a look at the offer and ticked in their own head how many issues they saw, there are going to be 4. So we're only halfway through dissecting this offer. The next one, now it says in the offer at least 21 days. Now the issue there is that this is arguably a breach of 36.5(1)(c), because it does not allow the recipient to ascertain the expiry date of the relevant period. It says at least. Now, as we all know, the expiry date for a Part 36 offer needs to be ascertainable. It needs to be clear, and it needs to be put in lights, because in those circumstances, that's the only way one knows how to calculate the interest on the costs and for what date they may be assessed on the indemnity basis. For example, say if it was a fast-track trial, you'd simply go along with 2 schedules, and one from the expiry of the relevant period and one from before. So this date is really, really important. So any offer that is put in these terms, at least 21 days, well, this is very basic stuff. Not only will it lead to not being a valid Part 36 offer, when one applies one's mind to it, it simply cannot on any basis, because it's unworkable. So this is a really basic one, and because this always comes at the tail end of any offer, you might write a long letter lambasting the other side, telling them how rubbish their case is, and the reality is that the at least the 21 days provision will probably be one of the last words on the page. But don't get it wrong. Okay, this goes back again. I'm harping back to it. Read Part 36, cover to cover. Know what you need to do and stick to it. So that's a really basic one, but you will see it eventually somebody getting it wrong. Now, this last one isn't strictly as to whether the offer is valid, but rather it goes to the question that the judge must ask, whether or not it would be unjust to award the Part 36 consequences. Of course, they're not mandatory, but they are, unless it would be unjust to award them. And again, it's important to keep this in mind, because what you don't want to do is make a very good, otherwise valid offer, pitch it at an appropriate level so it bites, but get it wrong on the basis it's not a genuine attempt to settle. So this is the case of Yield Point, another High Court decision from last year. And what was the judge saying there? So the Part 36 offer in that case was for 99% of the principal claim. And there were some points about interest, but so essentially it gets us to 96% of the claim value. And the judge took issue with this upon being invited to by counsel, because was this a genuine attempt to settle, or was this, in effect, one of the parties saying to the other, give up, or you are going to be liable for all our costs? So this offer is not saying we take into account some litigation risk, and therefore, we'll settle 75%. It is simply asking for everything. So, of course, this was a massive litigation. If we boil it down to your garden variety fast track claim, £20,000, say it's under free invoices for the provision of services. When we make offers to settle, we likely say to our clients, look, we have these different issues, £20,000, would you walk away for, say, 15? That's how these conversations usually go. And that's how really you make an actual tangible effort to the other side to settle. Making an offer in terms of 96%, down from 99 due to complicated calculations of interest, simply isn't. So what did the judge say about that? Essentially, that the themes emerge. The theme has emerged for all the authorities that such a very high offer can only be vindicated where the claim itself was obviously very strong and be so characterised at the time of the offer. So let's pause there. At the time of the offer. So what you can't simply do is issue your particulars of claim, claiming your £20,000. The day after, make a Part 36 offer for £19,500. Really, you're going to find yourself in much difficulty, because at that point, the other side haven't given a defence, you've had no disclosure, and you've had no witness evidence, perhaps no expert evidence if that's relevant. So look at the time you're making the offer, and it's assessed at that point. That's very important to note, because otherwise what you would have is just every case that was issued, you'd nearly always have Part 36 offered made straight away. And the judge sets out at paragraph 21 some helpful guidance. It's objective and needs to be conducted free from hindsight, gifted by a trial and its known outcome so far as possible. So, for example, we're making our offer after a particular claim. We might know full well that their star witness is going to collapse in the witness box, or maybe not turn up, or maybe move abroad to New Zealand in the coming weeks and never be seen again. But it's at the time it was made. So again, don't let hindsight creep in. And when looking at the strength of an offer at the time, really bear that in mind. Is it a genuine attempt of settlement at the time? And I've somehow skipped a few slides there, but the important thing to note about this one is it's less binary and certain than the first three examples. What we're not doing is pointing to strict provisions in CPR 36, where we're talking about the words unjust. Now, with any element of the CPR, be that the Denton principles, for example, there is a lot of discretion for the judge. So really, don't for a moment think that there will be any certainty when arguing that an offer pitched too high will be rendered unjust and the consequences not awarded to the offeror. Because the judge made it clear here that, for example, in the case of Royal Bank and Travellex banknotes, a 99.7 offer was held as perfectly fine, and that the cost consequences were awarded there, or a 95% offer in the case of Jockey Club Racecourse and Wilmot Dixon Construction, or even down to a 90% offer in JMX. But what the judge was keen to put on there is that this does not dictate any sort of benchmark in terms of percentages as to what is acceptable and what isn't. It's illustrative guidance, but nothing more. And what I'd advise anyone to do if they were considering an offer of this nature that they thought was pitched far, far too high, is read the case of Yield Point. Really get into the judgment, look at the cases referred to, and go on from there. because it will give you a feeling for what will be acceptable and what won't be. But as I've said, it really is this element here, looking at the offer at the time it was made, that will give you the best feeling as to whether or not it's going to be acceptable. So I see we've got some questions in the Q&A, and I've purposefully kept this discussion brief in terms of my planned element for several reasons. Firstly, going back to the offer that was made, I picked out 4 issues there. There may well be more. Had I come up with a different scenario, there would have been different ones. Part 36 is full of trapdoors and things you can get wrong. So what I didn't set out to do is give an exhaustive account of how to avoid every potential pitfall. Rather, what I hope to do is demonstrate how an otherwise valid offer can really quickly be picked apart without too much effort, that to really put this on everybody's radar, that Part 36 offers need proper consideration. So any questions, please pop them in the questions box, but I've got a couple already here. The first one is, should you inform the other side if you see an error in the offer? What's the best way to act in this situation? I would say that there's no obligation to let the other side know about the issue in the offer. What I would say is, put it in layman's terms, keep stum. The offer is still an offer. It will still be considered under Part 44 if the judge sees fit, but Part 36 consequences don't bite. What the other side will be doing in their letter is they will be saying this is a Part 36 offer. They will read you the Riot Act and tell you all the things that could happen to them if you don't accept. But you're not obligated to tell them, so I would not tell them. Next one, would a claimant Part 36 offer to discontinue a money claim in return for a small fixed sum stated to be in respect of costs be valid if argued? Again, I will go flip back to the case of Night and Night. I would say you're on very dangerous ground if you do make any provision as to costs. And that's because Part 36 is a relatively strict regime. The costs are simply those those incurred. There's no scope within the regime to make offers as to costs. So I would say that's probably not going to be valid in respect of Part 36 consequences being ordered. So I'd be very, very careful. Next question, what about offers made pre-action when nothing has been pleaded at that time? That is a very good question, and probably a very difficult question for the judge to answer. I think the answer probably is that you're okay. But I think it will likely depend on what subsequently is pleaded thereafter. And I think my gut instinct is that if you make an offer, a Part 36 offer that seeks different remedies that aren't then subsequently pleaded, I think you may struggle. But I'm not aware of an authority on the point. And as I set out, there are numerous other ways one could fall foul of the regime. So that is perhaps one. Next one, does the new fixed cost regime affect the wording of Part 36 offers? I must confess, this talk has not delved into the murky world of the new fixed cost regime. I'm going to say no, not that I'm aware of, but I'm aware of some talks coming up, the King's Young Professionals dealing with the fixed cost regime. So what I think I'll do is put that on the radar for one of those, for somebody to talk about Part 36 offers and specifically in those consequences. And the next question very much falls on from that. From working it through in practice, it seems incredibly complex. And that is a Part 36 offer following the new fixed cost regime. Yes, I think it will be incredibly complex. And I think also, because of course we're only talking about claims issued October 23 onwards, and there won't have been that many of such exercises taken place. So if you do find yourself having to deal with that, the likelihood is the solicitors on the other side are dealing with it the first time, and the judges as well. So, that is going to be difficult, and it's not something I've had the pleasure of yet that there are other questions to the fixed cost regime, and I think what I will do is definitely put this on the radar for somebody to pick this up and do a talk, because I think it's likely to unveil many different potential questions. We'll do a couple more questions. What if the other side specifically asks you to alert them if Part 36 offer is defective in any way? Could we be criticised, penalised if we do not? Interesting. I think you'd have every ground to say the other side is simply being cheeky, and it's not for you to point out where their work is wrong. In the same way, you wouldn't send a particular claim and ask the other side to point out if you're missing anything. So no, I don't think you need to be worried in those circumstances. What is the difference between part of a claim and certain issues? I think this will be referring to pleaded claims, parts of claims or issue, and not any other claims or issues. I think that's part of the decision that is a little bit unclear, and it's not exactly certain what it means by that division. As I say, nothing is set in stone here, and it may well be difficult to read the authorities and work out if you're going to be on the right side of them or not. That's past everyone. Thank you everybody for coming, and thank you for those questions. Obviously, I haven't had a chance to get through them all, and apologies for that. But if anybody would like to get in touch to discuss anything specific, please let me know. I'm happy to chat through them. Of course, we can take this in a million different directions when we talk about 36 offers. The complicated beast, but hopefully I've whetted the appetite of those watching, and next time you see an offer, you'll give it a good kick around before you simply accept that it's valid. Okay, right. Thank you everybody very much. And as I say, there are many more of these talks coming up. So please do tune in.